The erosion of legal protections for the preborn in America were conceived in rape and then progressively expanded to cover additional circumstances. In 1966, Mississippi became the first U.S. state to allow abortion, but only in cases of rape. In 1967, other states began to change their abortion laws based on the 1962 American Law Institute Model Penal Code, which allowed for abortion in cases of rape, fetal deformity, and threats to the life or health of the mother. In following years, other states followed suit and allowed abortion for the same exceptional circumstances. So the legal strategy of those who favored abortion was very successful. It leveraged public sympathy over rape and other difficult circumstances in order to violate the sanctity of the womb and violently force a policy of abortion on demand upon an unwitting populace. By 1970, the gloves came off, and Alaska, Hawaii, Washington, and New York repealed their abortion laws altogether and allowed for abortion on demand. This led up to the U.S. Supreme Court ruling in the companion case to Roe v. Wade, called Doe v. Bolton, which struck down a Georgia law which allowed for abortion in exceptional cases. The court ruled that by allowing abortion in certain circumstances, the state was admitting that the right to life was not absolute. If abortion was allowed in cases of rape, there was no justification for the state to arbitrarily prohibit abortion in other certain circumstances or any circumstance whatsoever. So by 1973, the wheels had come off and abortion on demand had prevailed. Since then, it is estimated that over 50 million abortions have been performed in the United States without legal opposition. So it might be said that the whole judicial policy of the United States regarding abortion was, in a certain sense, conceived in rape.